Hey everybody, welcome to Lawyer Live with Matt the Lawyer. I am Matt the Lawyer, Matt Johnston. Before we get started with today's topic, which deals with contracts, I do want to remind everybody, hey, you can go check out my ebook on the Facebook. You can get it on my blog or on my webpage, and you can get the ebook, which will help you draft contracts that work for you and your business. So, today's topic is about what I like to refer to as squishy language. Other people refer to it as legalese. Other people refer to it as crap contract language. Here's the deal. There's a case that was recently decided out of the 7th Circuit Court of Appeals, which is based over in Illinois primarily. And the case is called I hope I don't butcher this name too bad, so sorry folks if I do, the Prushinsky Trust versus Kaw Valley Companies. And the details of the case are kind of more or less irrelevant, but essentially it was a contract for a lease of a mining operation and payment of royalties, and how the Prushinsky Trust was going to make some money based upon what this mining company was doing, getting minerals and stuff out of the ground. So that's kind of where the case was. Here's the problem with this particular case. This case arose simply because of bad contract drafting. That's the only reason this case came about. Because one party thought that a provision, which I'm getting ready to read to you, meant one thing, and somebody else thought it meant something else. And when you have that situation, you are lacking an understanding between the parties. So here is the short sentence that is at issue. And the heart of this provision was a minimum royalty payment that was going to be made. So the court put the whole thing in there, and I'll link to the court decision in the notes down below. But here's the provision that came up. Notwithstanding anything to the contrary contained herein, lessee shall pay to lessor an annual minimum production royalty of $75,000. In quotes, minimum production royalty. In quotes. All right. That's the provision. Now, this provision contains a whole bunch of things that are bad. Really, really bad. So, first of all, we're going to talk about the word notwithstanding. Notwithstanding is what I like to refer to as a remote controlled detonator. It's going to blow up something somewhere else in the contract. So whenever you use that or whenever you see that, you need to start looking around for language in that contract that is about to be destroyed. In this case, they were talking about something herein. Herein what? Herein this particular section, which is dealing with royalties. Herein meaning the whole contract. Herein meaning a subsection. We don't know. That's the problem. It's squishy. Herein is a very nice legal term. It means nothing. That's really what it does. It means nothing. Herein is so squishy, you don't know what it's referring to, and that creates a problem. Then you get into what the court talks about a little bit later. They talk about a annual minimum production royalty. And minimum is lowercase. And then we talk about the production royalty of $75,000 that is referred to as the minimum production royalty, all capitalized, minimum being capitalized. So once again, we see this sentence that created an entire court case, including an appeal, probably cost the participants hundreds of thousands of dollars, when it could have been something very simple. Okay, how do we address this problem? Instead of using something like herein, specifically refer to the section. Say, notwithstanding anything in this section, or notwithstanding anything in this agreement, or simply say, there will be a minimum annual production royalty of $75,000. Period. That's all that had to be said. But instead, the lawyers who drafted this contract went into the world of legalese, went into the world of traditional contract drafting, and created a situation in which it was entirely possible that whenever this production royalty dropped below $75,000, that there was going to be an argument about what was happening. And it's an avoidable argument. It's an argument that didn't have to happen. And it happened because the parties did not understand what was being said. If you're going to have a contract, and particularly if that contract is talking about money over a long period of time, then you have to be able to understand it. And one way that you can do that is to avoid sentences that use things like notwithstanding and herein and having confusing language. Okay? So, in the end of the day, the Prashinsky Trust lost on their case. They believed that the herein referred to just this paragraph. The Caw Valley said, no, it's the whole contract as everything. And that's traditionally how it goes. But here's the thing. They could have avoided the problem. So if you have a clear contract and everybody understands that contract and you're not making assumptions that everybody understands that contract, clear contract language avoids disputes and saves you money in the long run. In the meantime, this is Matt the Lawyer signing off. Go out and watch some live soccer. Bye-bye.